Our guests today are Deborah Meshulam, a partner of DLA Piper, and Dixie Johnson, a partner of King and Spalding, both here in Washington, D.C. They're securities litigators, SEC enforcement pros. I've always wanted to do a program on insider trading policies from the litigator's perspective, and today's the day we're doing that. I'm Brock Romanek, today on Zippy Point. So Deborah and Dixie, thanks so much for doing this. As I said in the introduction, I've been wanting to do the program on insider trading policies from the litigator's perspective for a real long time. And you two really fit the bill. You've been doing this for a long time and are great at it. So we're going to kind of go through what an insider trading policy says and kibitz about, why that might be worded this way or that, and have other tidbits that you'll be sharing. So Deborah, the first question, we're going to swing it to like the introduction, the purpose. Why do you have an insider trading policy at all, that kind of thing?
Yeah, sure. Thank you so much, Brock. And I just want to say I'm very excited to be included in this. It's great to be able to have this conversation with you and Dixie. And I'm really looking forward to it. And hopefully it will be helpful to our audience. So let me just start with a reminder that insider trading is and remains a very hot topic. Congress is very much focused on the role of corporations in permitting trading by executives in advance of disclosure of material corporate news. And just today, the Insider Trading Prohibition Act went from the House, was passed in the House, and has gone to the Senate, where it is expected to pass. And so for the first time, it may be that we're going to have a law that explicitly prohibits insider trading. Federal and state regulators are all over this issue. They continue to scrutinize suspicious trading. And, I anticipate that the scrutiny is just going to increase, and this is going to remain a really important issue for the regulators and prosecutors. So let me start by saying that unlike the case for broker-dealers and investment advisors, public companies are not required by law or regulation to establish an insider trading policy. But even though it's not a requirement, when I look in this space, it is a company is well advised to put in place an insider trading policy for several reasons. First, it helps protect the corporation in a number of ways. It protects the corporation from claims that somehow maybe it facilitated improper, illegal trading by its executives, its officers, directors, employees. It can help the company prevent its employees, officers, and directors from being caught up in inadvertent trading because they don't know how they should treat their awareness of material non-public information. It can help a company minimize the risk of getting caught up in these investigations. So frequently I see companies getting inquiries from the Financial Industry Regulatory Authority, the SEC, asking for all sorts of information related to trading after that company made an announcement. And even those initial inquiries can be expensive. If one of their employees or directors appears on a list of individuals who have traded, the costs just go up exponentially as a company has to deal with that and consider whether it has to do its own investigation, consider whether it has to address governance issues in the event that someone may have purchased or sold company stock while aware of material non-public information. And importantly, having an effective policy helps protect a company's reputation. It won't find itself in the headlines because there's been a discovery that, someone on its board or a main executive may have traded in stock in front of some public announcement of important information. And if that does happen, an effective policy that was followed can protect the company from the fallout because, ideally, if everybody is following a well-written policy, they will, there won't be an issue. And so those are some of the reasons that it's important to have these policies. And I would say that although there are not many cases where companies are sued for insider trading, outside of, let's say, the regulated entity space, the risk is there because there is a law called the Insider Trading and Securities Fraud Establishment Act, commonly called its FIA, where a control person, which can be the corporation, can be liable if it's reckless in failing to take the right steps to prevent insider trading. And so those are reasons why it's important for a public company to have this policy in place and to draft it properly and to make sure that it can be effective depending on the nature of the business, the size of the business. And, over the course of this program, Dixie and I are going to talk about some of the key aspects of an effective insider trading policy, looking at it from the view of folks who find themselves defending companies and individuals who are caught up in these kinds of issues. And I would say just, the starting point is really understanding what is material non-public information. And so Dixie, maybe you can provide some guidance on that.
Sure. And that was a great overview, Deborah. And I think you hit all of the notes. There is one area that we aren't going to cover today, which is trading by the company itself. We'll be hitting on 10b5-1 plans, but not 10b5-1 plans by the company. And we aren't talking about repurchasing company stock. So all of those touch on the trading activity, and it's trading by the company. Just as a footnote on that, it probably, Brock, is worth doing something else on that one, because in the fall, there was an enforcement case about a company violating internal controls requirements for not catching that it had material non-public information at a time when it was repurchasing its own stock. So different topic, different day. Material non-public information is one of those concepts that everybody kind of knows when they see it, or you hope they would know. It is defined, it has been defined through case law through the years. And the technical definition goes back, tracing all the way back to Texas Gulf Sulfur in 1968 and TSC Industries in 1976 and Basic v. Levinson in 1988. If there's a substantial likelihood that the disclosure of the omitted fact, which is the material non-public information you're evaluating as to whether it meets the definition, if there's a substantial likelihood that that fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available to the market, then it's material. That is typically evaluated in hindsight, after the person evaluating it knows how everything turned out. They know when that information was revealed to the public, whether the stock price moved. Stock price movement isn't per se material, but it sure is an indicator that the regulators and private litigants use to evaluate trading activity and make arguments based on that evaluation. So fact finders will look for any indication that the material non-public information was known at the time. So one of the reasons these things are so expensive, as Deborah mentioned, that includes looking at board resolutions, instructions to investment bankers, negotiations between principals or their intermediaries if you have a transaction, or if you have problems within the company, who knew what when, is always really the question. And as one court put it, the determination of materiality requires a delicate assessment of the inferences that a reasonable shareholder would draw from a set of facts and the significance of those inferences to that reasonable investor. Whether investors are reasonable is always a question to consider. We've had a lot of examples back in the .com days, and again now in the cyber world, a lot of activities that aren't traditional investor activities are now happening. And so looking at materiality may happen through a new lens, but I think it still goes back to what reasonable investors would be looking at. And just as an example, that is a moving analysis. So these days, when you're looking at ESG, for example, ESG activities are very much in the focus of very prominent investors right now. So what might not have been material in an investment analysis years ago may be now. So it's a moving definition. The last thing I would mention is that the SEC looks at SAB 99, its own staff accounting bulletin, to evaluate materiality, and looks at it through a lens of qualitative materiality on the one hand, which tends to have a dollar threshold. How important would it be to the financial performance of the company? And also a quantitative, also a qualitative lens, which involves the softer things like conduct and whether there was bad intent going on, whether the activity that is known could have altered a prior period's reported results, even if just a little bit, but therefore made them miss analyst consensus. Lots of stuff happening on the materiality front. It's a hard thing to analyze. And so I think that's why we get to policies that draw some bright lines around conduct and around who can do what when. And so we're going to talk for the next little bit about the scope of policies, and Deborah's going to start with who's covered by them and what this Section 16 officer category is all about.
Great, thanks, Dixie. And I want to just reemphasize a point you made, which is the concept that materiality is not static. It changes over time because, as we will discuss through the course of this discussion, insider trading policies also have to evolve as the business evolves, as what's viewed as material evolves and becomes known. And so I would start with one principle that I think is really important when you're thinking about the scope of an insider trading policy, and that is you need to understand your business and put in place a policy that is going to work for you, because having a policy that may look good on paper but that you cannot effectively implement and enforce will create just as many issues as not having a policy at all. They'll be different, but just as many issues. But there are certain guiding principles that pretty much any insider trading policy should address in terms of scope. And the first is that it should cover all company officer, directors, and employees. And it should also cover their family members and others who live with them. And usually the policy will define these people as insiders. And it's important to cover family members or others who live in an employee's household so that your employees understand that they are not free to share material non-public information with a significant other so that the significant other can trade. The other guiding principle in terms of scope is that the policy should apply to all transactions in the company's securities, and it should also apply to transactions in the securities of other companies where your own insiders may obtain material non-public information as a result of doing business with that company. Examples could be you have a joint venture partner with whom you're working, and you learn something about that partner's business that is material. Or it could be a key vendor but it's the concept that the scope of the policy is a little broader than just the company's securities. The policy should, as Dixie referenced, it should spell out typical examples of what is material non-public information for the company. And I'm not going to go through a long list, but mergers and acquisition activities, financial results there. We'll talk about the evolving nature of this a little bit later, but most policies will spell out what basic examples of materiality so that those who read the policy and are subject to it at least have some understanding of what the company itself views as its own material non-public information. Also, policies typically spell out what sort of activities are prohibited. And typical activities that you see prohibited are, of course, trading in the company's securities while aware of material non-public information concerning the company, tipping others about that information, providing trading advice about company securities, hedging transactions, trading on margin or pledging company securities, trading, tipping, or giving advice on the securities of other companies where the insider gained material non-public information in the course of his or her work, with that other company, and participation in chat rooms, blogs, websites, bulletin boards, in a manner that's somehow inconsistent with the policy. In other words, not going onto a chat room and just saying, we are going to knock it out of the park at the end of this quarter, while you're aware that your company's about to announce really fabulous results. So those are some of the sort of general rules of the road that really would apply to everybody. But there is a category of individuals known as Section 16 insiders, shorthand, and they are typically subject to other requirements in an effective insider trading policies. And these individuals are officers and directors of the company, and those beneficial owners of more than 10% of the company's stock. It's a group of individuals who are defined and who are subject to what's called Section 16 in the Securities and Exchange Act. They have special reporting requirements related to when they transact in the company's securities. Typically, an insider trading policy will include their family members as Section 16 insiders, and many companies are also will identify other key employees who are subject to similar requirements in the same way that Section 16 insiders are required. And the basic limit that you see for Section 16 insiders in virtually every insider trading policy, and honestly, I can't think of one where I haven't seen it, is that these special Section 16 insiders are only allowed to trade company stock during a specified period when the company has an open trading window. And the trading window is basically when they're allowed to trade. And the usual trading window will be a period of time shortly after the company announces its public results for a specified period, a quarter or a year, and then Section 16 insiders can trade for a period of time leading up to a moment when the company is likely to have enough information to understand what the next reporting period numbers might look like. And just as an example, you could have a trading window that opens 2 days after the public announcement of quarterly earnings and stays open until, let's say, the end of the second month in the next quarter. Often the people who administer the policy will provide Section 16 insiders with a trading window schedule that spells out dates when that window is open. And so Section 16 officers are subject to that extra limitation. But in addition to the limitations that apply to Section 16 insiders, there are also times when a company will direct key personnel not to trade because of other events that are going on inside the company. And that is a special blackout period. And Dixie, if you could talk a little bit about those and how they work and why they're important.
Thank you, Deborah. And I would just add to the things to think about in the context of what trading should come into the scope of a policy, the question of industry-based mutual funds or index funds. For companies in very narrow industries where their activities are really market moving, trading in those funds, it may be worth thinking about whether those ought to be captured in the policy as well. It's kind of hard to know. It's a very individualized analysis.
Yeah, no, it is a really good point. I have seen that in some policies, and one of the points that is relevant is there's a consideration of how thinly traded the particular stock is that goes into the analysis of whether the policy is broader than a typical policy and includes those types of funds. And so, the thinly traded stock is another area to consider in terms of scoping out prohibited activities.
Exactly. And Section 16 officers, of course, also are prohibited from buying and selling within 6 months because they're not allowed. Well, they can do it, but then they have to disgorge their profits to the company. Yeah, so it's another prohibition that's usually part of an insider trading policy. Typically, companies, of course, handle, and this is and also another program for discussion. Typically, companies support those officers by handling forms 3, 4, and 5 that the officers are supposed to be filing. And it makes sense for companies to help on that front. But again, that's another topic, and it's why all those transactions are public when shareholder lawsuits are filed and you end up in very visible allegations of having material non-public information at a time of trade, which typically are not proven, but you end up with allegations anyway, which is a pain in litigation.
Yeah,
but on the blackout,
let me just add, since we brought it up, and it is another program, but the requirements for filing when Section 16 insiders have to file those forms 3, 4, and 5 it's not as simple as just when you buy and sell. There are nuances to that can be very complex, which is why I agree it should be another program. And on the short swing profits, the 6-month rule that Dixie mentioned, shareholders can bring a suit to force the corporation to recoup those profits from the officers, which again can add litigation costs. That's happened. And there is an ongoing debate that I've seen about whether you include some of the Section 16 insider requirements that are not necessarily directly related to insider trading in the insider trading policy, or whether you have a separate Section 16 officer policy. And again, that's something for another discussion, but I've seen that done both ways, and it's really a function of what will work best for a particular company. But back to blackouts.
Yeah, totally agree. So as Deborah mentioned, most policies are structured and kind of with 3 buckets of people in mind. One is people who cannot trade if they personally have material non-public information, but otherwise there's really no prohibition on their trades, and there's no period that will restrict them from trading. That typically happens in really large companies where there's so many employees who might trade, who are so far from possibility of having material non-public information, that having an additional threshold other than their own policing would be difficult. However, it's kind of rare these days, I think, to have a lot of people who are subject to their own self-review of material non-public information, which really just parrots the law that you can't do this, and a reminder of that. There's a second bucket, which is what Deborah was talking about, not being able to trade in blackout periods. And the reason for that, a blackout period is a time, as Deborah mentioned, typically around financial reporting, but it can be broader than that. And it can arise around a specific transaction and around a specific group of people. The concept is that you can't trade during that period because there's kind of a presumption, or at least a big risk, that material non-public information exists in the company, and because of who you are as an executive, you probably have it. It doesn't mean you have material non-public information, but if the company policy prohibits the individual from trading, it protects the individual from an allegation later in hindsight to evaluate whether material non-public information was present. Then there's a third bucket, which is that sometimes people are not allowed to trade in the blackout periods. And even outside of the blackout periods, there has to be pre-clearance due to a position in the company that you're likely to have material non-public information pretty much at any time. And so our teams spend a fair amount of time counseling companies on focusing on who should be in which bucket based on that, in that kind of a structure. And these days, with so many SPACs being formed and new public companies emerging who haven't gone through the IPO process, so they haven't had to learn how to be a public company in the way that traditionally companies have learned. In those situations, really evaluating what the company is, what its business is like, those are all important for evaluating how to structure the buckets of categories of people and what they need to do. In addition, there are sometimes exceptions to the policy, and I think pre-clearance kind of fits in that. And sometimes at the end of the process, there may be a certification. So Deborah, do you want to focus a little bit on exceptions to insider trading policies?
Yeah, sure. And I guess I would just add, in terms of how the blackout works, it's really important for a company to make sure that its employees understand the buckets, and that just because you may not be in the blackout bucket does not mean that you are free to trade. It's we've seen so often circumstances where an employee who's not in a blackout, but who is somehow aware of material non-public information, feels free to trade, not because of any necessarily bad intent, but because of a lack of understanding that even though there may be a blackout that applies to a certain group of people, it does not automatically translate into the ability to trade if you're not on a blackout. And, I think one of the themes you're hearing from Dixie and me is the importance of making sure that your employees understand how these policies work. And so I want to highlight that with respect to blackouts, and we'll talk about some exceptions to the policy now. The good news is that not every transaction is always prohibited under these policies. There are certain categories of transactions that, even if you have a blackout, even if there is material non-public information, transactions can be permitted. The classic example is a transaction where the other party to the transaction is the company itself. And that's because both the employee and the company are assumed to have the same material non-public information. There's no disparity. And so there's really no insider trading. Often these transactions will have, the price of the stock is not going to vary with the market because it's fixed by an option agreement or a stock purchase plan. And so you have an officer, director, or employee buying or selling shares directly from the company. And what are those situations? It could be acting to satisfy tax obligations related to equity awards or engaging in transactions based on standing instructions. So you can have typical exceptions would be exercising stock options or similar equity awards, or returning shares to the company in payment of the option exercise or to satisfy tax withholding obligations. But there's a limit. You can't sell the shares that you acquire after you go through this transaction while the insider has material non-public information or is subject to one of the blackouts that Dixie described, or if they're a Section 16 individual, or a key employee where their trading window is closed. They can exercise and keep the stock. They can't sell it in those circumstances. Another typical exception is if you buy or sell company stock under a 401k plan or an employee stock option purchase plan, provided the transaction is conducted pursuant to standing instructions that were put in place while the insider did not have material non-public information or was subject to a blackout or a closed trading window. And you can think of an example of this, in a number of companies. You can have employees who will authorize a certain portion of their paycheck to be deducted and applied to the purchase of company stock, just as one example of how that might work. And, as long as they set that up in a way, when they weren't subject to a trading window or a blackout or had non-material, non-public information, that's good to go. The other main area where you can have transactions take place without violating an insider trading policy will relate to 10b5-1 plans, which are permitted under the securities laws and which allow a corporate insider to essentially cede discretion over his or her transactions to an investment advisor or broker dealer who will then engage in those transactions without any input from the executive. But it's not quite that simple, and there are important rules to make sure to include in an insider trading policy so that 10b5-1 plan sales are appropriate and permitted under the law. And Dixie, if you can take it from there to talk about the thorny issue of 10b5-1 plans, which this year have been under very heavy scrutiny from Congress in particular, which does not currently seem to like them very much.
That's exactly right. Congress doesn't like them very much. And it's understandable because the purpose of a 10b5-1 plan, which is allowed by the SEC's rules expressly, it's an affirmative defense to allow you to set up trades in advance, have no control over them, and then they just run no matter what happens in the company. So in the time of COVID, you can see the circumstance where an executive would have set up years ago, maybe, a 10b5-1 plan at a time when that executive didn't have any material non-public information and was allowed to trade and got all the approvals necessary. And the plan was to sell a certain number of shares every quarter at a certain point in the trading window if the shares were trading at a certain price or under a certain price or over a certain price. And then COVID hits. And everybody's looking at their portfolios, stock prices are going in wild areas, and the things that people didn't anticipate happening are now happening. And so on the one hand, boards gave executives stock grants, anticipating that that would be part of their pay. And extraordinary events aren't the executive's fault, right? So why should they have to stick to a 10b5-1 plan set up before a natural disaster was known, and continue to sell shares at a point when the stock price is so low? On the other hand, why should they be able to sell at a stock price that's really high when the company knows that there's going to be a lot of strain on the company later in the year and hasn't yet disclosed that? So there's material non-public information floating around, even though the terms of the specific plan are established in advance. Nobody wants the appearance of having taken money off the table when other investors didn't have that information available to them. So a 10b5-1 plan set up in advance works, but often people get nervous about it and want to cancel it, either because they don't want the appearance of taking money off the table when other investors don't have information, or because things have changed and they just don't want to, they realize the flaws in the plan and they don't want it to continue functioning in the current environment. Typically, if you do cancel a 10b5-1 plan, it will capture the attention of the SEC staff. And certainly if you cancel and start one up again in any time period that doesn't involve extensive cooling off, that's going to attract the attention of the enforcement division as well. Because since this is available as an affirmative defense, you have to enter into it in good faith. And if they're starting and stopping to try to game the market, even if that's not the true intent, it's likely to be reviewed in hindsight. Companies also have 10b5-1 plans. Again, this is not today's subject, but there certainly are issues around that. And another area of potential restriction outside the concept of a 10b5-1 plan, but a similar way of divesting shares, maybe even on a regular basis. Sometimes insider trading policies exempt gifts and donations. And that can get really tricky if the gift ends up being made to a charitable trust where the individual knows immediately they're going to get the deduction. The trust is going to sell those shares right now, and then donations can happen from there on out, but the deduction happens immediately for the transfer to the trust. So that's a hot issue that people are looking at now, and it's causing some interpretive challenges. It's causing some interpretive challenges for people reviewing policies. But back to the terms of the insider trading provisions itself, that whole pre-clearance topic is a challenging one about, who should be the person who pre-clears, who should pre-clear the person's trade who normally pre-clears. Deborah, you want to dive into that thorny subject?
Absolutely. I want to add just a couple of things about 10b5-1 plans, because usually a company's insider trading policy will also spell out some rules of the road for the establishment of 10b5-1 trading plans. And it's important. And, typical rules will lay out when someone can establish a 10b5-1 plan. And again, it goes back to some of the the comments I made on exceptions, which is you have to establish it when you don't have material non-public information, when you're not subject to a blackout, or when you're not subject, in the closed window. So there's typically a time period when you can set it up. The policies will usually have rules that impose a cooling off period so that you can set it up, in this open window, let's say, but you can't conduct your first trade until the next open window. So there's a bit of a cooling off period. There are frequently rules for when you could amend or alter a plan. And so, for companies that are working through their insider trading policies, they ought to consider what are the rules of the road for employees to engage in, to open or amend a 10b5-1 plan. And that really feeds into this concept of pre-clearance, which is another way for company insiders to try to trade in company securities without running afoul of the insider trading policy, the securities laws, and many policies will impose pre-clearance procedures, particularly on Section 16 insiders and often other designated key employees. And just at a high level, pre-clearance is going to require that the individual seeking to engage in a transaction, and that would include gift transactions such as Dixie described that are very much a hot issue, they have to give notice or get approval from a designated person prior to engaging in the trade. And the first issue is it merely giving notice and a passage of time, or do you have to have affirmative approval? And I've seen it both ways. Certainly getting affirmative approval is the more conservative approach, but again, it's important to think about practicalities. There are no specific requirements, and it really is going to depend on your company. So that's one of the first decision points you would have in your insider trading policy for pre-clearance. And then the second is who exactly should give approval. And the typical candidates are the company's general counsel or a specified designee of the general counsel, some lucky person in the legal department, a chief compliance officer who may be described as the general counsel, because in some companies, the general counsel is also the chief compliance officer or is designated as the chief compliance officer for these purposes, and also sometimes the chief financial officer. Those are the three typical individuals who are designated as the person to pre-clear. And well-crafted insider trading policies will also have a special process in place, who pre-clears if the general counsel wants to trade, or the CFO, or the compliance officer. And again, there are other formulas for who has that responsibility, and it will rotate in terms of who gets designated. And what you see also in insider trading policies is, often the person who's designated to pre-clear is also the person who is in charge of administering the policy, because someone or some office has to have the responsibility for making sure that the insider trading policy is administered, meaning that it is, rolled out to the employees so they know about it. People have received training on the policy. People are following the policy, and, someone's available to answer questions. And so typically those functions are rolled into either the legal or compliance functions, although pre-clearance, again, can go to the CFO, who will have a sense certainly of who may have the most, material non-public information, at least about the company's finances. In the case Dixie mentioned earlier in our discussion, where although it involved the company's stock purchase plan, it was a 10b5 plan, the internal control failure related to claims that those in charge of administering the policy didn't have an appreciation for what material non-public information actually existed within the company at the time the stock buybacks were approved. And so it highlights how challenging this can be and why it's really important to think through who the appropriate designee for pre-clearance ought to be. And how that person can make sure that they in fact have the right information to make a decision. And, part of the pre-clearance, the other aspect of pre-clearance are the practicalities. How far in advance must the person who wants to trade seek pre-clearance? What is the form of their request? Should they give a written certification that they don't possess material non-public information? Those are some of the practicalities. I think, again, considering what your company can do, it absolutely makes sense that at a minimum, there should be, a reasonable period of time before the trade where the request is made, and that the request should in fact be accompanied by a certification that the individual seeking to trade does not possess material non-public information. The other aspect, some other practical aspects of insider trading policies relate to how to report violations. Where do those reports go? How are they handled? Typically an insider trading policy will specify that anyone in the company aware of a violation must report the violation. And they may even direct that reports of the violation go to a designee, again, including, the general counsel or the compliance officer, the CFO. But in practice, what I've seen is that these types of reports will also come in through the company hotline, and either way, they will get rolled up into the appropriate process for reviewing these allegations. And who reviews the allegations raises privilege issues. Insider trading policies really can trigger a number of these privilege issues. And, just some of the questions to think about at a very high level is whether the policy itself is privileged, because it is talking about, could be viewed as giving advice on what the legal requirements are related to insider trading. It is going to the whole employee base. However, at least my experience, the policy is typically not privileged, although drafts that are created by lawyers or at the direction of lawyers would be privileged. Another question that typically comes up in the privilege space is whether a blackout notice issued under the policy is privileged. Again, because it is giving, in some ways, you could view it as giving legal advice as to, we're now at a point where we have material non-public information and, these risks exist. Again, typically, blackout notices are not treated as privileged, but they should be drafted carefully so that you don't fall into a situation where maybe you're inadvertently revealing legal advice. Same question about whether requests for trading and pre-clearance and the response privileged. Again, the answer is typically no. This is not, seeking legal advice. It's an individual who wants to trade. It's not, providing advice to the company, which is really the client of any lawyer who would pre-clear. They're not representing the individual in that case. Is training on the policy privileged? That's an area where, depending on the content and who's providing the training, you could maybe make an argument that it's privileged. But often training on these policies is developed with outside vendors and not necessarily lawyers, in which case it's unlikely to be viewed as privileged. Are reports of violations privileged? Generally not. But you get to the next question, what about investigations of claimed violations? Are those privileged? And again, that will depend on who's conducting the investigation and how it's conducted. As a former SEC enforcer and as a defense counsel, I tend to prefer a situation where if you have a potential violation of law, it's being investigated in a manner that the investigation is protected by the attorney-client privilege, leaving the company the option to decide whether to waive that privilege. But there are, again, other models, if it is a compliance function that is investigating violations, asserting the privilege over that is less likely to succeed. So you have a violation, it's reported, and you have a reported violation and it's been investigated, and maybe there's a violation of the insider trading policy, which isn't necessarily a violation of law, but nonetheless, you have a violation of a corporate policy. Dixie, what do you do with someone who may have violated a policy? What are the sanctions? What are the penalties?
That was a great overview, Deborah, and you're exactly right. It is not the normal thing that happens in a company to realize that you have an executive in the middle of an insider trading issue. It raises a number of different things for the company, including when the government comes investigating, is this indemnified activity? Or is it something that really the individual has been doing on their own to trade in securities, and therefore they have to cover their own legal expense? Lots of questions arise in that area. There can be sanctions and penalties by the company itself for the individual, and that typically is handled, as you've alluded to, by the company itself evaluating its own history of compliance enforcement and remedial activities. Most companies have a program of what happens when a violation of company policy is reported. And that program typically would involve in some kind of disciplinary action after the investigation happens. If you find that somebody did something wrong in an insider trading situation, it often could result in dismissal from employment. At that point, though, that's not really what the worst thing is that is facing the employee who traded. Insider trading is a violation of the basic anti-fraud rules under the federal securities laws. As Deborah mentioned at the outset, that could change soon. We could have a new statute. Maybe by the time you're looking at this video, there's a new insider trading statute. But even if not, the violation is considered part of the anti-fraud structure in the Securities Exchange Act of 1933. And the sanctions that are provided include sanctions that were provided in an Insider Trading Sanctions Act in the late 80s. And the basic structure is a disgorgement of illicit profits, ill-gained profits. So if somebody has made profits by trading at a low price, buying securities at a low price prior to a known event that was going to increase the price, that gain is an ill-gotten gain that the SEC, if following up on an enforcement matter, would say that individual must pay back. There is also the concept of losses avoided. So if you sell shares at a time when you anticipate that the company's stock price is going to go down, the SEC would take the point when that news that caused the market price to go down is public, and look and watch the stock price movement, and whatever you would have made by selling your shares at that later date, when the information is fully available to the marketplace, they would do a subtraction calculation, and the amount of loss that you would have incurred selling the shares is what your disgorgement amount will be. Notwithstanding the concept that if you had known that, you would not have sold the shares. You did, and so there's a disgorgement amount. The SEC already also has the authority to get pre-judgment interest, or it believes it has that authority. We'll get back to the belief of the authority on disgorgement in just a moment. Pre-judgment interest is the concept that the SEC takes a long time to get to the end of the day on an insider trading action, but meanwhile, you've had the ability to use this money you gained that's in your pocket, and so you should have to pay interest on it. And so typically what they do is go back to the the time of the trade and move forward to the point of the time of the settlement, unless actions are taken earlier, and calculate prejudgment interest at the IRS penalty rate, which is not really, there are disputes about that too, but it's a punitive interest rate that is the default rate that the SEC likes to apply. And then the SEC has penalty authority of up to 3 times the amount of the disgorgement. So it's not just a calculus of, well, if I have to give the money back, I have to give the money back and I'll pay interest. It's that much again, the amount of the disgorgement again, and up to 3 times the amount of the penalty. In addition, before we get to the nuances of some of those, every federal securities law provision with the right level of scienter, certainly anti-fraud provisions, can be criminal activities. And you've seen lots of activities in putting people in jail for insider trading and tipping. So the worst thing that can happen is being put in jail. There also is authority by the SEC to do corporate officer and director bars as a result of fraudulent activity. And we've seen some of that in the insider trading space. Now, the SEC's faced a lot of challenges in courts relating to its authority. The United States Supreme Court has looked several times at disgorgement. And in the middle of last year, after a case called Liu, L-I-U, the SEC enforcement staff began settling cases for a double penalty, 2 times what would have been a disgorgement amount, and not even charging disgorgement. The normal formula for settling for many years has been, you pay to, if you're going to settle the case, you pay the disgorgement amount of the profits gained or the losses avoided, prejudgment interest, and then a one-time penalty in the same amount as the disgorgement amount. Once there was pressure on disgorgement from the Supreme Court, we started to see some settlements out of the SEC that are in the same dollar amount they would have been previously, but just charging a double penalty and no disgorgement amount. We'll see what happens if we end up having a new statute on that front. Looking at the insider trading front, the SEC can bring its cases. They have the choice of forum in federal court or the administrative forum. There are lots of reasons to prefer one forum or another, but federal judges sometimes do things differently than what the SEC would do in a settlement. And the SEC does litigate its cases. And it can litigate them in the administrative courts, but typically they prefer to litigate insider trading cases in federal court. And so those are some of the follow-ups that may happen, and the downside of a finding of an insider trading piece. Just one more point on that. If you don't trade at all, but someone who the SEC can prove that you've been talking to, and hopefully they can prove that you actually passed information that was material non-public information to them. If that person has a duty not to trade, either because they're your therapist or your lawyer or some other reason why they have a duty to protect that information, then they can be liable for insider trading, and you can be liable for tipping. I think tipping actually is the biggest risk for corporate insiders, because the SEC operates on circumstantial evidence, and they find the traders and then work their way back and see who had the information at the time. So penalties for tipping are the same as for trading. You can be penalized, and you can have to disgorge the profits that somebody else made, which can be very frustrating in the moment. So let me stop there and turn it back to Deborah to kind of wrap up some of the issues about the policy, and obviously to fill in any additional comments on the sanctions and penalties front.
Yeah, thanks, Dixie. One point you made at the very beginning of the sanctions and penalties related to indemnification. And what I have seen is case law that says that, in fact, companies will have to indemnify officers and directors and other employees who might be covered, because sometimes indemnification will cover a broader group. Even for these insider trading investigations. And, that is just another potential cost for companies if they get caught up in these types of investigations. And yet another reason why you want to really make sure that your employees and your officers, directors, and employees understand what's at stake, understand what your policy is, so that they don't violate it and don't engage in insider trading. And, we've talked a little bit about training and how the company can make sure people understand. And in that arena, best practice is for a company to make sure that its employees acknowledge that they have received and read the company's insider trading policy, both when they first are made aware of that policy, which is often right at the time they're being hired, and then even after, they've received additional training and any other updates on the policy, because as we've talked about, the policy is not static, it does change over time. And, certainly regular training is very important in this area. And, what's the form of that acknowledgement? It really varies, and you have to think about what makes sense. If you have a workforce of tens of thousands of employees, you're not going to be able to collect, formal written acknowledgements. It may be that a online click system, or some electronic method of collecting acknowledgements is acceptable. Usually an employee will sign something right when they come on, so you have that initial written acknowledgement, and thereafter you might have electronic acknowledgements. But for Section 16 individuals, it's really important. They're the individuals who are most likely to have material non-public information across a broad array of, corporate issues. They are the individuals who have transactional reporting requirements under the securities laws. They are the individuals subject to the short swing profit rules, and they're really the leaders of your company. And so in that context in particular, it is important for a company to require that such individuals, who are usually a pretty small group, provide a more formal acknowledgement that they've read and understood the policy, that they've taken the required training, that they have received and read updates to the policy that may come out on, an intermittent basis. It's, relatively easy to do. Officers and directors, they frequently get annual questionnaires that ask about these topics, and that is, a vehicle to get that acknowledgement. But it's important to recognize that your key officers, directors, and employees should have, as a best practice, a more formal obligation to tell you that they've read and understood their obligations. And how do they read and understand their obligations? Well, it's a matter of communicating effectively with your officers, directors, and employees about your insider trading policy. And let me turn it back to Dixie to talk about some of the ways in which companies can effectively communicate the insider trading policy and its requirements.
As you can tell from our discussion today, this can be a very complicated area. And however, you're drafting a policy or maintaining a policy for people at all levels of sophistication within the company. So my preference is to have a policy that is relatively simple and plain English, as we used to say in the securities world many years ago. that describes clearly what people are supposed to do and gives them step-by-step instructions of what they should do and where they should go. So I think step one in effective communication is really taking a look at that policy and making sure that it's clear. There can be a loop, a revision loop. If the company has a practice of updating its policies on a yearly basis, the people who get the pre-clearance questions during the year may also get questions about, well, I can't tell from the policy, does it prohibit this or does it prohibit that? If part of that loop is for those notes to be retained until it's time to update the policy, you can be really happy that that has happened in the meantime. And this may be a good time. If there's a new insider trading law, it's just kind of a natural time to revisit the policy and make sure that it tracks with the current state of the law and requirements. And as we've mentioned throughout today, the other methods of communication include that moment of the pre-clearance conversation where an officer has been asked to pre-clear someone else's trades, where you're talking with them and think through together material non-public information and what it is, and could this be material non-public information? Could that be material non-public information? That kind of counseling can be another way of effectively communicating the policy to help people understand that, as we've said, it's not just that you can trade in an open window with a check the box pre-clearance. It's really an analysis of whether it's okay to trade now. And finally, training, of course, and the certification process, if you have one, like Deborah mentioned, are additional ways to communicate the policy. It's good to change up the training, have different people come in, do some sessions that are live, some sessions that may be recorded. It's always good to change it up so that people don't get bored and so that you can catch their attention. Current events always capture people's attention too. So major cases where people have gotten caught inadvertently with liability or had close calls on that. I've done a yearly series of articles for 7 or 8 years now about inadvertent tipping. And it's because corporate officers just get caught by surprise sometimes when people around them are trading and they might not have had any idea. So keeping an eye out for that kind of thing is also a good thing to remind people about. Policies should be living, breathing documents that can go with the flow of any changes and of any fads or news items when people have new ideas about how to trade. But I think our last topic really focuses on what do you do with hot topics, cryptocurrency, cybersecurity breaches, what the latest fad, how do you balance between a living, breathing document that's flexible enough to apply to any new or novel situation that arises versus modifying the policy to expressly address something? Deborah, you want to close us out with that?
Sure. So I guess I'll say it's not easy finding that balance, because if you're constantly updating your policy and sending it out, eventually your audience is going to have policy fatigue and they just won't pay attention and it'll be hard to keep up. And so, you know, when I talk about this with clients, I try to make sure that they understand that when you're crafting your policy, you want to have a broad principle that captures the concept of newly emerging issues that are going to impact the company in a, you know, potentially material way. And so that even if it's not explicitly laid out in typical examples, the reader, understanding plain English, will understand that, wow, we've had a cybersecurity breach and, you know, or we've had a ransomware attack. It's impacting our operations. I shouldn't be talking about that, and I shouldn't be buying or selling our company's securities. And so, you know, you start with this general principle that's easy to understand for the audience in terms of, you know, think about what can really impact our business. And no matter what it is, if you see something like that, if you know something like that, don't trade or get pre-clearance, so you have that broad principle to start with. And then at appropriate moments in time, when you're updating your policy, whether it's triggered by the passage of the new law, whether it's part of a yearly update that is communicated through training, you can provide additional examples and update the examples based on knowledge of the business and what's going on around the corporate environment that could, lead to material impacts on the company's business. And Dixie mentioned earlier in the conversation ESG as an emerging issue of great importance to a lot of investors. And so a company could, flag that in a regular update, but a well-crafted policy will capture that in its broad description of what is material non-public information. Other hot topics to think about in this area that you want to make sure your broad description would capture, and you can think about whether it's appropriate to update, in addition to these climate or other environmental events, but we've talked about cybersecurity breaches, of course, and that would include not only a hack or a breach, but ransomware attacks, all of the forms that could be captured in the concept of cybersecurity. I also think that certain types of government investigations can rise to the level of material non-public information, particularly if you think about Foreign Corrupt Practices Act investigations or major False Claim Act investigations. And again, these can be captured in the broad concept and considered as specific topics during a regular update. And they can also be woven into periodic training even before you amend the policy by giving examples. And one of the discussions I have with clients is, when you're thinking about your insider trading policy, think about your risk factors, because your risk factors can trigger material events in this way, these hot topics that are not maybe classic material non-public information, such as a great new contract or loss of a key client, customer, but sort of the broader issues. And that's I think the best way to handle these issues without making yourself crazy.
Yeah, and let me just follow up and say, sometimes people draw a line on whether to amend the policy by whether the government, some entity, the SEC typically, issues guidance that hints that they're going to be watching for policies. And so in the cyber area, that became a pretty hot topic. And therefore, it's not surprising that many policies now expressly address cyber breaches as one of many ways that you can have material non-public information. But Deborah's exactly right. You can't draft around everything, and that's why it has to be really broad.
Right. So, yeah, another area that on that same topic, the impact of COVID. But that, to me, ultimately is going to be a temporary. I like to think we'll get past COVID, and so that ultimately the impacts of that will move beyond those. But yeah, I agree completely, Dixie.
And Brock, thank you for inviting both of us to join you for this discussion. I've had a great time, and Deborah and I always just love discussing issues like this. So to have an opportunity and an excuse to do that, we really appreciate it.
Yes,
Well,
thank you so much.
I made 570 videos, and this is the easiest job I've had. It was such a comprehensive look. It was fantastic. And thank you so much for being with us.
Thank you again for having us.